The second case on the docket for Friday, February 4th, 2022 is Appeal Number 122331, State of Kansas versus Jeremiah J. Tafolla, Sedgwick County. Briefs both sides. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please come to the lectern and state your appearances?
May it please the Court, Jennifer Roth from the Appellate Defender Office appears on behalf of the appellant Jeremiah Tafolla. Present and ready for argument.
May it please the Court, Assistant District Attorney Lance Gillette on behalf of the State of Kansas, present and ready for argument.
Ms. Roth, you may begin your argument.
Chief Justice, I'd like to reserve 4 minutes for rebuttal, please.
4 minutes is reserved.
May it please the Court, again, I'm Jennifer Roth from the Appellate Defender Office appearing on behalf of Jeremiah Tafolla, the appellant in this case. By way of short factual summary, I'm assuming that we should still give those for the folks at home. Mr. Tafolla registers for a severity level 7 aggravated assault from 2011. The state alleged that he did not come in to the sheriff's office in January of 2019, which is one of his 4 reporting months. The only details we have in the record about that noncompliance come from Mr. Tafolla himself at the sentencing, where he explained that he went to the state hospital during January and didn't intend to miss. And the record also shows he was in custody about 3 weeks after the date of the charge. He pled his charge to a core noncompliance, a level 5. The court followed the party's recommendations and departure factors and placed Mr. Tafolla on 36 months of probation. He tested positive for drugs, agreed to serve a probation officer imposed 2-day sanction. Shortly after, he tested positive for drugs again. He admitted to this sole violation at his one and only probation violation hearing. He argued to remain on probation. The state opposed that, saying that he was not amenable to probation, which is what the court also found. The court sent him to prison for a little over 11 years. The issue in this case is simple, in my mind. In 2013, the legislature substantially altered the parameters that a district court judge has when sanctioning a person for a probation violation. The legislature restricted what a judge can do when a person violates their probation. KSA 3716, which is a self-contained statute, everything we need to know about what to do when a person is facing a probation violation is contained there. And it requires the judge to impose graduated sanctions before they can revoke and send a person to prison, although they have a range of options. Under certain statutorily specified circumstances, the legislature allows that judge to find an exception to bypass those sanctions. So we also often call these things bypass exceptions. I'm not telling you anything you don't already know. But to me, the issue here is clear. The legislature spoke loud and clear that it was changing the way we were going to do business with people who were facing probation violations. And what we see happening in this case is that despite that being the law for 6.5 at least years, the district court did not order Mr. Tafolla to serve a prison sanction before revoking and remanding him to serve 11 years for core noncompliance. In order to skip that step, the district court had to find that a statutory bypass exception applied. And the court's reason for sending Mr. Tafolla to prison was a reason that's never been applicable in the life of 2170. The court's specific reasons that it gave on the record were Mr. Tafolla's mental health challenges and substance abuse issues. And those are not statutory exceptions. In fact, they are the reason that the legislature passed 2170, because the research and the proponents and people's lived experience and the testimony of the people at 2170 was that the best practice is to keep people in the community and to get them help there. and that revoking is a last resort.
Interrupt you real quick. When did the dispositional departure exception come into play?
July 1, 2017.
Okay, so that wasn't 2013, that was 2017, correct?
Right. So what happened? Sorry, go ahead.
So what you mentioned was that a court has to find an exception before it can revoke probation without imposing graduated sanctions. And I would agree with you in the 2018 version, subsection 9, which says the court may revoke if the court finds and sets forth with particularity the reasons for finding safety of the public will be jeopardized or welfare of the offender. But when you get to 9B, it doesn't say anything about a finding. It just says the court, the court may revoke if the probation was originally granted as the result of a dispositional departure. So where is it that you're concluding that the court has to make a finding?
I think I wish I would have used a word other than find, because I wish I would have used the words that this court uses, like invoke or, let's see, apply. Let me look. That implicit findings aren't good enough. They have to invoke an exception, bypass exception. They have to utilize a bypass exception. They have to properly analyze and invoke one.
Okay, let's use the word utilize.
Okay.
All right. So the court may revoke. Why do you have to make a finding? Because it's pretty much an undisputed fact in the record that your client in this case was originally, his sentence was the result of a dispositional departure. Why do you even have to make a finding when it's basically undisputed? Do you dispute that? It didn't seem like it.
I dispute that he got a dispositional departure and everybody knew it. I don't dispute that.
Right.
But what I do dispute is that these things just apply without anybody invoking them. And it's interesting, there are 4 ways in 2018 that you can bypass. We've talked about one of them that has the word finding. It's my recollection that the other 3 don't mention finding, yet there are instances, well, I'm trying to think about.
Well, abscond.
Yeah, it doesn't have the word finding, yet this court has said you have to make a finding.
Right, because that's the nature of the word abscond, which is basically, can be a disputed fact. But here, whether or not your client was sentenced as a result of a dispositional departure, there is no dispute here.
To me, the fundamental part of this is that the legislature has said that the presumption is that you will get a sanction. And if you want to do something other than the presumptive choices you have and the order in which they occur, and because remember, the whole reason we're having this conversation is that he never got a prison sanction. They went straight from probation ordered 2-day to prison. And so the reason we're here is that the judge skipped the step of the prison sanction. And so to me, the thing is that the legislature has shown us that this is the order, that if you want to go beyond the presumption, then you have to invoke it. And so even though we all know you got the departure, you have to say that is the reason for your discretionary decision, is my contention.
And what are you basing that on? That the court has to say it? Because it's
I feel
sure
like
not in the plain language of the statute.
I feel like I'm basing it on what this court has said. Now, I understand.
In what case?
I understand that Dooley, Clapp, and Wilson don't involve dispositional departure. But what I feel like that this court was saying in those cases was you have to invoke. You have to explain that you are invoking one of these bypass provisions and that we're not going to just implicitly try and sort out what you meant or what you could have said or what you could have done, but what you actually did, and that you have to invoke those. And so I believe that even though those cases I just mentioned aren't about dispositional departures, that the reasoning and what this court said should apply here to the fourth thing that a person can get sent up for.
Okay, let's say that we agree with you,
Okay.
all right? In this case, the state stood up and said, here, we would like you to revoke and impose the sentence. He's not amenable to probation because of his criminal history, probation report, because he received a downward dispositional departure, and then the short window. And then your client's counsel got up and said, we agree that the court granted a dispositional departure to address substance abuse, but he's still struggling. And the district court says, right off the bat, you're right, this was a dispositional departure, and I'm trying to remember the exact thing he said, which was, the court reiterated the basis of the defendant's departure. So it went through, the role that mental health played, your willingness to engage in mental health counseling, your agreement to drug, alcohol, and mental health evaluations and follow the recommendations. And then he said, you're not following through on what you were told to do at sentencing. Why isn't that enough facts to show that the district court was revoking because of the dispositional departure under subsection 9?
Because of the next thing that the court said, which was, at this point in time, the court finds that the defendant's substance abuse issues and mental health challenges deem him unamenable to probation. The fact that you're not following through on what you were explicitly told you needed to follow through the time at sentencing, having revoked your probation, I'm going to impose the original sentence in this case.
Right, but
to me, he didn't say, I'm revoking it because you got a dispositional departure.
But he says that after he says what the reasons were for the dispositional departure, which incidentally correspond to why he is imposing the sentence. I mean, it all kind of dovetails.
I obviously, I cannot dispute that everybody there mentioned the words dispositional departure. But to me, when you look at what the court said as for why it was sending this man to prison for 11 years, it wasn't because he got a dispositional departure. It's because he had two issues, substance abuse and mental health challenges, which incidentally, ironically, is the point of 2170, is to keep people in the community to treat those sorts of things. And so I understand.
But that's the reason he got the dispositional departure.
That's part of it. That's
Right.
part of it. Part of it was also the age of his convictions, the role that the mental health, the man said he was in the state hospital when he was supposed to report. I shouldn't be arguing. You're right. Everybody mentions the dispositional departure. But my point is that nevertheless, we have what the judge said. And interestingly, this court has also said that sometimes you look to what journal entries say. And in this instance, part of the problem is that Sedgwick County does not actually use the approved form. But if you look at the journal entry of this gentleman's probation violation, you will see nothing in there about invoking a statutory exception, not durational or not a dispositional departure, not anything. And so we cannot, to me, that helps my point that not only do we have what the judge says as the real reason, but we also have a journal entry that gives us no backup to what the judge might, if the judge was actually using a bypass exception. Or the other thing I think I would mention, because it seems a little related, I have no idea. If I can finish this question, I think I must be out of time.
Sure, yeah.
Related to your question, though, Justice Standridge, is also I think it's important to look at what the court said when it started towards the beginning of the hearing. And it suggests to me that nobody was even thinking about the option that the court had that I'm saying the court needed to do, which was the prison sanction. So when the court is explaining to Mr. Tafolla that if you admit to your probation violation, then I'm going to revoke your probation, which, number one, that's not the term you use anymore. You haven't used it since 2013. And the second thing is, then the court says, so then my options will be to, quote, reinstate your probation under the same or different conditions, or I can order you to serve the remainder of your sentence. No reference to any sanctions. And then the court again tells him, well, your probation's hereby revoked. That's not what you do under 2170. And so
Is there
to
any
me-
obligation for preservation purposes for your client's counsel to have asked for more, to actually asked for intermediate sanction, prison sanction?
I don't think so. I understand that people will disagree, that there are unpublished opinions that disagree from the Court of Appeals. But to me, this has been considered by the Court of Appeals in a published opinion for the first time. And the other thing that I guess I just can't get past is that the judge is the one doing this sentencing, and the judge should know the law, and the judge should follow the law. So I would assert that you can consider this, even though apparently nobody mentioned what was probably, what was obviously an option here.
Thank you, counsel.
Ms. Roth, before you sit down, and this is a little off topic, but I want to get a picture of what happens here at these revocation hearings, in court cases and in all cases, but maybe in court cases especially. Was there an attempt, once probation was revoked, to revisit the duration of the sentence, which is possible on revocation?
Did anybody ask for that?
Yes.
No,
Okay. But it is possible.
it certainly is.
Yeah, and so as a result here, Mr. Tafolla received an 11-year sentence, which is probably a lot more than what the underlying crime called for and what he served.
At one point, I figured it out, but, yeah, it's
But-
$341,000 taxpayer money, but
I'm just concerned about the time, and so, but that never occurred here, but it can occur here. Okay.
it certainly can. There are multiple cases, not to mention 223716 itself says that there can be less time.
Thank you.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. The one thing that I think opposing counsel and I can agree on today is that this is a very simple case. This case began with the claim that the court erred in applying a version of 223716, which eliminated the option of what's colloquially referred to as the KDOC soak. That issue is no longer really here. The question is whether or not 223716, specifically C9B, allowed the district court to bypass the intermediate sanctions. The state has two arguments on this point. Number one, I believe, as Justice Standridge pointed out, the plain language of this statute does not require any specific finding whatsoever. That language is distinct from two other specific provisions within the same statute, specifically C9A, which requires a finding and setting forth with particularity the reasons for bypassing sanctions, as well as 3716C4, which requires, again, a finding and setting forth with particularity the reasons for making a bypass. Moreover, not a single case that has ever been cited by the defense supports their position. There's not a single case, unpublished or published, from this court or any lower court that supports their position that any kind of explicit finding is required. I took Justice Standridge's question to basically speak about absconding and that to be the Dooley case. And Your Honor is correct. In order to find an absconsion, I don't know if that's a real word, but to find that someone is absconded, it is necessarily a factual finding by definition. That's not what we have here. That's not required here. There's no additional factual finding required here.
Mr. Gillette, the only thing that, I kind of see this as two competing legal questions of law or the legal error. We've got the plain language, which that came out in questioning. But in the decisions by the Court of Appeals, and they can all be distinguished, but in Duran, Combs, Hill, they use these words that say, you cannot affirm a district court for a discretionary decision that the district court never made. So give me your thoughts on that.
That is true when you are applying the laws at issue in those cases. That's the fact. To make a bypass finding and impose it in every single one of those cases, it required some explicit finding on the record, be that danger to the community, danger to themselves. Again, that kind of specific finding is absolutely not required under the law that applies here. It just simply is not.
But how do we know that that is, we can take the facts away a little bit and say that there was no mention of dispositional departure at all. Okay, we'll use that hypothetical.
Okay.
All right, so they come in and the judge says, I'm going to revoke, impose the original sentence. Boom. Doesn't even mention the word exception. All right, so the statute, when we're talking about the plain language of the statute, C9 says the court may revoke, that's discretion, and then A is, the safety of the public. But B, so the court may revoke without previously imposed sanction if the probation was granted as a result of a dispositional departure. But if the court never invokes, or where it's not clear from the record that the court used its discretion, how can we affirm the district court for a discretionary decision it didn't make?
I think I would offer two responses to that question. And here the panel below at the Court of Appeals points out that it is reasonable to, it's when there is absolutely no objection, the standard rule from this court is to presume that the district court found all facts necessary to support its judgment. That is a presumption that would apply here. And then my second answer would be that a dispositional departure and its existence, it is, I guess, would be a set finding of fact. There's no additional finding that would be required to revoke probation at all. I mean, once the departure is granted, I guess another way to look at it or to phrase it is once a departure is granted, these intermediate sanctions, they do not apply as a matter of law. We're on a completely different track here because these defendants that receive dispositional departures receive the utmost grace offered by the district court.
Counsel,
Yes.
I'm sorry. Are you saying that had the district court imposed an intermediate sanction, that would have been an error of law?
No.
Okay, so let me tweak the hypothetical a little bit and get at what I think Justice Standridge might be asking. What if a district court says, this defendant comes for the revocation hearing, and the district court says, well, I see that you got probation as a result of a departure, and because of that, the law really ties my hands, and I really can only either not revoke or revoke and impose the original sentence. Would that be an error of law?
I believe it would be.
Would it be a district court judge failing to recognize that it has discretion to do something?
I believe that it would be. And
Okay, so then the obvious follow-up is, how do we know that that's not what this district court judge had in his or her mind?
I think we can know that here.
How, though?
Based on the record in this case.
Well,
Because
can
this
you point
district
me
court, yes,
to where we can?
this district court had imposed a prior intermediate sanction for this defendant. He had authorized that through the probation officer, number one. And number two, again, I think has been pointed out, everyone in this case, including the district court, acknowledged and found that defendant received his probation as a result of dispositional.
Right, but that's irrelevant to my hypothetical. The question is whether or not the district court knew that it had discretion to impose an intermediate sanction. Because if the district court didn't know that, I mean, arguably that's an error of law, and this goes to Justice Standridge's point, which you can't affirm the exercise of discretion when the district court didn't even know it had discretion.
And I think the record here definitively counters any argument that the district court did not know that it had discretion.
So your argument is we can affirm this district court because we can tell from the record that it knew it had discretion and it exercised that discretion.
Correct. And one other thing I think I'd point out, just I recalled from the record, the district court here also considered placing the defendant in a intermediate residential center and found that that was not an option based on his particular criminal history. So I think that again emphasizes that this district court knew discretion and it chose to not exercise.
That's really based on having done the two-day jail sanction.
That, and again, as I just recalled, the acknowledgement that an intermediate sanction for a residential center might be possible in some cases, but not for this particular defendant.
We're throwing hypotheticals around. Let's say we don't have that. We have a sentencing where a judge comes in and says the things that this judge said, which is basically, you're not amenable to probation. We've given you a chance and you failed. And that's all that's said about why I'm doing what I'm doing. Is it enough in that kind of a situation that even though the judge may not have considered the graduated sanctions, that there's this backstop because the statute allowed the bypass because of the dispositional departure?
I mean, I guess, and not to, I don't want to undermine my answer to Justice Stiegel, but I think that there is this backstop here. I cannot say with certainty that the failure to recognize the discretion definitively be an error of law, because again, there's no specific finding required when a defendant is not on an intermediate sanctions track. This is a completely different track of probation, a completely different type of probation. All ordinary, I guess, quote unquote, ordinary offenders would be faced with and entitled to.
Here's what troubles me about this case is that Mr. Tafolla, or however you pronounce his name, is exhibiting the exact behaviors that the district court found was not amenable to probation, but that behavior is exhibiting the behavior that is exactly what intermediate sanctions are designed to address. That's what they're there for. And that's what, over and over, that's what the Sentencing Commission, that's what the legislature put in place for intermediate sanctions, is mainly addictive behavior, mental health issues. That's what he was exhibiting. It just seems like this fits the basis for allowing an intermediate sanction before revocation. And I appreciate they didn't have to, but I don't understand the skipping of it in this instance. It wasn't like he committed another crime. It wasn't like he did something out of what, in the context of what intermediate sanctions were designed for. That's exactly what they were designed for.
And I think that is a fair characterization for someone that's on this standard intermediate sanctions track. A defendant like Mr. Tafolla was never on that track because he received a dispositional departure, which is
I understand.
Which is a kind of grace that is immense. The court was taking a very significant risk. It made, and I would point out that the same findings that allowed
risk, but the kind of the core violation was as a result of this. Of the behavior of his mental illness and drug addiction, most likely.
Possibly.
Okay.
Unless there are further questions, I thank this court very much for its time this morning. I ask that the district court be affirmed. Thank you all.
Reserve 4 minutes.
Thank you. Just want to address a few things that the state mentioned. First of all, it is true that for people that commit offenses from July 1 to 2019 no longer have the option of a prison sanction. I would argue that it's things like this case that led the graduated sanctions to not work quite as intended. But at any rate, the point is that Mr. Tafolla would still be eligible based on the State v. Dominguez that tells us that amendment only applies to people whose crimes were committed on or after July 1, 2019. So this prison sanction is still available to Mr. Tafolla if this court were to reverse. Other thing I wanted to say is that this is not a separate tract. I don't know, I might get in trouble for this because it's not in the record, but the state is telling you that this is somehow or another, Mr. Tafolla and people who get dispositional departures are somehow or another separate and apart from the other three exceptions. But when that exception for the dispositional departure was proposed by the District Attorney Association, and they made clear in their testimony that this is not, it is clear this amendment does not prevent the court from allowing a defendant another bite at the apple and opportunity at a graduated sanction. These things are all in the same statute. They're in fact in another 9 has 2 things in it. There's something else, I can't remember which one, with this dispositional departure. And again, 3 out of the 4 bypass exceptions do not use the word finding. But this court has told us a number of things. Number 1, you do make a finding when you do absconding. And the other thing that I think about this court is in Dooley, when you used words that explained that this is, regardless of the exception, I think that what you're saying in Dooley is there's 2 steps. Sometimes you make a factual finding, but there's also a procedure, like procedurally, are you invoking the statute? And so, yeah, we know he got a dispositional departure, and you know something else we often know is that a person has stipulated to committing a new crime. But you still have to invoke that exception before you bypass the sanctions and send a guy to prison for his original sentence.
Was the district court, in your view, was the district court aware that it could have imposed intermediate sanctions?
So, thank you. One of the things on my sheet is to address what you had mentioned. And I would go back to what I was talking to Justice Standridge about, that when you look at what the court was saying before they even start the dispositional part, the dispositional part, when they're talking to my client about, do you want to waive your hearing about your allegation? And the court's explaining to him, well, these are my choices. They're using the court's using the wrong words, and they're not mentioning the fact that you could even get a sanction. So I believe that that is evidence that the court's not aware of what its options are.
And how would you respond to opposing counsel's suggestion that we can know that the court was aware because the court had previously imposed a sanction?
They had not. The only other sanction my client got was something he got from his probation officer. He hadn't been before this judge before, I didn't think. I thought he got because I think, I feel like I need to go read the record again, but I'm pretty sure that the 2-day jail sanction he got, yeah, I know this is true. He had to sign the thing saying I waive my right to a hearing and I agreed to go do my 2-day jail sanction because I'm positive for drugs. So the first and only time he was ever in front of the judge for a probation violation was when he sent him to prison for 11 years.
Was residential treatment an intermediate sanction?
No. That's not one of the, that's an option that you would have, but it's not a listed intermediate sanction. So, you know, in addition to the jail sanctions, which by the way, there's up to 18 days that a person can get. It's not like you just get one and then you go on down the road. That was not the intention of 2170. But to your point specifically, the sanctions are you get up to 18 days in jail. Then if you've gotten that, then you can get the 60 day or the 120 in prison. If you get that, you can get the 180. But there's not that would fall under one of the other just general things that the court could do.
Your position would be that the court's consideration of that request at sentencing doesn't give us any insight into whether or not the district court judge was aware of the intermediate sanctions.
That's just a place that you would be serving your probation. And that's something, well, actually, right, I didn't really think about Sedgwick County having one as well. But no, that's not one of the listed things. Just like the 60 days, you know, there's also a provision in 2237-16 that says you can do a 60-day jail sanction, but I don't know if it's this court or just the Court of Appeals, have said that's not one of the graduated sanctions. So I'd say the same thing about the residential option. Chief Justice, do you mind if I just wrap up? Okay.
You're welcome to.
At any rate, just in conclusion, the district court failed to comply with 2237-3716C. To be blunt, it is maddening that things like this continue to happen, just as they happened to Mr. Tafolla. At the time of the hearing in his case, it had been 6.5 years since 2170 had taken effect. Dooley had been in print for 1.5 years. Duran had been in print for 6 months, and that was a case from the same district, not the same judge, but the same jurisdiction. It's been clear for almost 9 years now that through 2170, the legislature was reforming probation and sentencing standards. It was codifying more chances. The legislature was following evidence-based practices to give swift and certain sanctions with an eye to keep people in the community and not sent to prison. The court sent Mr. Tafolla to prison for 11+ years because of his substance abuse issues and mental health challenges, which are the 2 reasons that they gave, which are not statutorily bypassed reasons. And interestingly, that is why he got a departure. Everybody knew he had these problems, yet he got sent to prison for them for 11 years. We ask this court to vacate Mr. Tafolla's 136-month prison sentence and remand his case for a new dispositional hearing. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement to issue a written decision.